She was taking it for Jamie.
This is Nora.
25 CR 40. 25 CR 497 is now called the State of Texas versus Carson Moore. Is that you?
Yes, sir.
Present with your attorney, Mr. Turpin, the state's attorney. Does the defendant with a formal reading of this indictment and arraignment, can we proceed inside?
You have a, she does.
In summary, this indictment alleges that on or about February 14th, 2025 in Jefferson County, Texas, you committed a second-degree felony of assault on a peace officer. Do you understand what you're charged with here?
Judge, let's make sure we're clear. This is going to be a lesser included of assault.
Do you understand what you're charged with in the indictment?
Yes, sir.
All right. That would be a second-degree felony. You have an agreement that I'm looking at that states you would be pleading guilty to the lesser Class A misdemeanor of assault, which carries with it up to 1 year in the county jail and/or a fine up to $4,000. Is that your understanding?
Yes.
You're looking over at him. But you understand the punishment range and what the plan is.
Yes, sir.
Okay. An agreement has further been reached. You would be pleading guilty to this Class A misdemeanor and placed on 2 years deferred of unadjudicated probation. Correct?
Yes, sir.
So if I follow this agreement, you have no right of appeal. You understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily?
Yes, sir.
That is on your own free will and because you are guilty.
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection admitted. The states you were mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your right to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. Are you totally satisfied with the representation provided by your lawyer? All of this is true, so help you God.
Yes.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report, Brad?
Yes, Judge.
Multitasking here and writing on the indictment. You have pleaded guilty to, which is the lesser included Class A misdemeanor. All right, I'm going to follow this agreement and find you are mentally competent to enter this guilty plea to this lesser included Class A misdemeanor of assault. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this lesser included Class A misdemeanor of assault. However, I'm going to instead defer any finding of guilt and place you on deferred or unadjudicated probation for 2 years. There will be terms and conditions of probation for this misdemeanor assault, not the least of which is you shall complete an anger management program. That's directing, which helps you make cool choice decisions when you're under pressure, which I think is behind all of this. And other terms and conditions of probation. Make sure you follow them. If you fail, your probation could be revoked. You could then be found guilty and sentenced up to 1 year in the county jail. Okay. You understand what's happening?
Yes, sir.
They see the probation office.
Auto.
That fast.
Sorry.
Just one thing.
Two cases. And this
Is he pleading to two or one?
It's pleading to two, and it's going to be a split sentence. It's going to be pen time on one, probation on the other.
Wasn't going to be easy today, was it?
No, sir.
You-
I was just following your example from years back.
My example. from
Yeah.
years ago.
You used to split sentences all the time. Oh, well, I'll go get on the phone too.
Two cases are called 23 CR 1745 and 1746. The state of Texas versus Tristan Kelly Dunham. Is that you, Mr. Dunham?
Yes, sir.
Present with, is Mr. Roebuck going to be the
Yeah.
lead with Mr. Roebuck as your attorney in this hearing? Does the defendant waive a formal reading of the indictment and the arraignment in each case here? And we proceed with summary. In summary, in 1745, this alleges that, well, they both, let's take them together. 23 CR 1745 and 1746 are individual indictments alleging second-degree felonies of manslaughter in 1745 involving vehicular manslaughter, and in 23 CR 1746, a second-degree felony of accident involving death. Oh, one fatality?
Yes, sir.
Two cases out of this one event, right?
Correct.
All right. Both of these, sir, indictments allege that this occurred on or about August 12th, 2023 in Jefferson County, Texas. And in 1745, the manslaughter, it is alleged that you recklessly caused the death of Christian Michael Sykes by operating a motor vehicle on a public road in excess of 100 miles per hour and failing to maintain control of the vehicle, which struck the rear of another motor vehicle occupied by the victim in this case, causing that vehicle to flip and leave the roadway, which resulted in the victim being ejected from that motor vehicle. Do you understand what you're charged with in the second-degree felony of manslaughter in 1745? And in 1746, this alleges that that you intentionally or knowingly drove a vehicle that became involved in an accident resulting in the death of the victim. And knowing that that accident occurred, you intentionally or knowingly left the scene of that accident without giving your name, address, registration number, etc., and without rendering reasonable assistance to the victim when it was apparent that he was in need of medical treatment, and that is in violation of the other offense called accident involving death. Each of these are second-degree felonies, which mean if convicted, you face no less than no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range that is applicable in these cases?
Yes, sir.
Agreements have been reached where you would be pleading guilty. Is it the same agreement in each case?
No, Your Honor.
In 1745, an agreement has been reached. You would be pleading guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. And there will be terms and conditions of probation, which
Judge, there's an agreement under the new law. You can order child support. They're agreeing to waive the ex post facto part of it, to waive the right to not rely on that law, but we've agreed that he's going to pay child support till the child reaches
How much?
18. That's going to be determined by the time we do sentencing. We're asking for a pre-sentence report because we're going to use the family code to determine it.
was he the sole provider of the deceased was the sole provider of the child?
No, sir. That's why he's got, there's a mother, and we just
Did the
got.
deceased leave a mother to the child,
Yes,
a wife?
yes.
Okay. Is she here by any chance? You are that, is she,
Yeah,
ma'am?
family's here. they're present, and this has been all discussed with the family before we made this decision.
This is agreeable with y'all? Okay.
The agreement we discussed prior to.
On this, in this case, he was going to be pleading guilty. He would not be found guilty, placed on deferred or unadjudicated probation, which can be up to 10 years in length. He would be fined $500. There would be terms and conditions of probation that this court can assess. And one of these is that the agreement that he is going to be ordered to pay child support in an amount to be determined by the court after the pre-sentence report is prepared. We're going to enter the plea, come back later and make sure that all the i's are dotted and t's are crossed and that everyone understands and is on board with the plan. Because this is changeable if necessary. And JCDI, okay, you have a substance abuse issue? No? Okay.
No,
All right.
that was a request of the family.
Okay. Well,
Yes, sir. I want to make sure.
so is this your understanding of the agreement on this case, 1745?
Yes, sir.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead in this case, charging you with the second-degree felony of manslaughter, guilty or not guilty? Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes, sir.
We're going to go to 1746. And again, does the defendant waive a formal reading of this indictment? Can we proceed in summary?
You do.
I think we discussed it, that you are alleged to have committed the second-degree felony of accident involving death. And in this case, you were facing a similar punishment range as the other, although third-degree felony is checked here. Can
Should
you
be
explain
second
that?
because of death. Should be second degree.
Okay, everybody right on that?
Yes, sir.
Because that's the way it's indicted.
Yes, sir.
The grand jury
Yes, sir.
indicted it as second-degree felony.
Yes, sir. It is second.
Okay, you're facing a second-degree felony here, which means you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand that, sir?
Yes, sir.
An agreement has been reached. You would be pleading guilty in this case and sentenced to 3 years in prison. That would not be suspended. That would be flat prison time.
Yes, sir.
Is that your understanding of the agreement, which would run concurrently with the preceding case?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge of a second-degree felony of accident involving death, guilty or not guilty?
Yes, sir.
Are you pleading guilty voluntarily, that is on your own free will and because you are guilty?
Yes, sir.
I'm going to show you in each case what has been marked as State's Exhibit 1. Did you sign those documents? Understand them, discuss them with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence
Okay.
without objection. It is admitted. Among other things, this states you are mentally competent in each of these cases to enter your guilty pleas. They are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you. You've read them. You are guilty of the crimes charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied by the representation by your lawyers. All of this is true. It states so help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes. We're going to have a pre-sentence report.
Yes, sir.
We're going to hold this in suspense. Order of pre-sentence report will return back on
January 5th.
January 5th. Good for everybody?
Yes, sir.
If not, let me know when you know something differently. Each side
I'll check with
will have
Pam
an
and make sure.
opportunity to add information. And at that time, then we will allow family under the law to make any statements that they feel like they wish to make. But I urge, let's not make a decision until after the pre-sentence report is read. And then the state will get with the family and go over it so that y'all know where everything stands on the facts. But we want to make sure that it is accurate. The record is accurate as possible. And as well for the defense, the defendant has his constitutional rights and he has his opportunity to discuss this with his defense so that they can represent him fully and appropriately. Anything else to add at this time? If not, we are in recess on this case until January 5. Thank you. Please get a resetting.